Hi, let's discuss the differences when a contract is void, voidable, enforceable, or unenforceable.
A contract is an equally binding agreement between two or more parties. It is an agreement to do a legal act for legal consideration. Preparation of contracts. A contract can either be in writing or verbal. A verbal contract is referred to as a parole or oral contract. Another form of contract is an implied contract, created by action, which implies that it exists rather than the terms being spelled out verbally or in writing. A written contract reduces the chances of future litigation. It also gives the parties the opportunity to take a second look at the terms and conditions of their agreement before finalizing it. Partial performance may cause an unenforceable contract to be deemed as valid and enforceable through court action. An example, an oral contract for a purchase and sale agreement, which should have been in writing to be enforceable, could be upheld in court if the buyer was allowed to take early possession of the property and subsequently made improvements to the property. Statute of frauds, contracts required to be in writing to be enforceable. Purchase and sale real estate contracts. Option contracts. Deeds and mortgages. Lease agreements when the lease period is for more than 1 year. Also required to be in writing based on the statutes of frauds are listing agreements when for more than 1 year, and any contract that cannot be performed for more than 1 year. Statute of limitations. Per the statute of limitations, a time limit is in place for pursuing a legal remedy in relation to wrongful conduct. After the statutory period, the injured person loses the right to file a lawsuit. Void, voidable, and unenforceable contracts. A contract may be void, voidable, or unenforceable. Void, voidable, and unenforceable contracts. A contract that is void is unenforceable. A void contract legally never actually existed. A void contract is one where it was impossible to perform the act described within the contract or when the act described is illegal. A contract that is void is a contract that does not meet the definition of a valid contract. It cannot be performed under the law. It cannot be enforced by either party. It does not meet the definition of a valid contract. And a void contract is treated as though it had never been formed. For example, Paul agreed to pay Samuel for the delivery of cocaine. If after delivering the cocaine, Paul refused to pay Samuel, Samuel cannot sue Paul. Their contract was for an illegal act. The contract would be void. Contracts that can be upheld in court are said to be enforceable. An enforceable contract is a legally binding contract that the law will recognize. An unenforceable contract can appear to be valid, however, if pursued for performance through the courts, is unenforceable due to some restrictions such as with the statute of frauds or statute of limitations. A voidable contract is one that can be upheld by one of the parties, but generally not all of the parties. One party is unbound and can cancel or void the contract. An example of a voidable contract is a contract made between someone of legal age and someone that is a minor. The minor can void the contract. The person in contract with the minor cannot void the contract. A valid contract that can be voided by at least one of the parties. The other party is bound to the contract unless also fits the definition of someone who can cancel a contract. And a contract with the minor is voidable by the minor. Enforceable. Contracts that can be upheld in court are said to be enforceable. An enforceable contract is a legally binding contract that the law will recognize. The point of entering a contract is to have the terms of the contract fulfilled. Upon a dispute between the parties, only an enforceable contract can be upheld by the courts. Enforceable contracts can be upheld in court and is legally binding contract that the law will recognize. Essential elements must exist for the contract to be valid. Essential elements include competent parties, offer and acceptance, legal purpose, and consideration. If any one of these elements are missing, the agreement will not be legally binding. The terms of a non-legally binding agreement can be met and honored. However, the parties have no legal stance to enforce the contract if things do not proceed well between the parties.